Hi, I'm Nate Langston, a partner here at the law firm and the litigation manager. I'm here to talk about litigation, what that means for your case. Litigation generally is the process by which we take a case from a lawsuit all the way to a trial. If your case is going into litigation, it generally means that the insurance company hasn't properly or fairly evaluated your case, and that in order to keep your case moving, we need to put a little bit more pressure on the insurance company by filing a lawsuit. Now, litigation can be a long process, but we want you to know that there are opportunities to settle your case all throughout the process of litigation. In fact, most cases, even where lawsuits are filed, don't end up in a trial. Only a very small percentage of them do. In general, there are 4 phases of litigation, and I want to talk about each of these 4 phases in a little bit of detail. First, there's the initiation process and initial disclosures. Then we have fact discovery, expert discovery, and then fourth, we have trial preparation and trial. The lawsuit gets initiated with the filing of a complaint. But before that's done, we need to gather a bunch of information from you so that we're ready to provide our disclosures. In Utah, the rules require that we front load the case with a lot of information that the other side gets to start the process. While we have most of that information already available, we will be asking you for some additional information, typically a medical history, and then also the names of friends, family, coworkers, other people that can help a jury potentially understand the nature and extent of your injuries. The lawsuit gets kicked off by the filing of a complaint, which is a legal document that gets filed in court, and it also gets served on the other side. They have about 30 days to hire attorneys and come back and respond with something called an answer. Once that's done, we get into the second phase, which is called fact discovery. In fact discovery, the parties gather information that is useful for the case. This is the longest part of the discovery process. It generally lasts about a year. And there are 4 types of discovery methods that the parties generally use to gather the information. There's subpoenas, there's written questions, there's depositions or oral questions, and then there's also medical exam. For the subpoenas, understand that the other side will use the power of the courts to subpoena all of your medical records and also your employment records if you've made a wage loss claim. Next, we have oral questions or depositions, which are the attorney's opportunity to sit the parties down and ask questions about the case. If it's a car crash case, you'll be asked about how the crash happened, what your injuries are, how those injuries have impacted your life, those types of things. The attorney representing you will also take the deposition of the person that caused the car crash or the business that was involved in the injury-causing incident, whatever it may be. That process, we will help you with the process. We will meet with you and go over what's expected so that you feel prepared for the deposition. You'll also be asked to answer written questions and provide documents related to the claim. And we get those questions, your attorney will get those questions, and we will work with you to provide answers. We have 28 days to answer those, and so you'll be required to work with us to provide that information. Lastly, we have medical exams. The insurance company has a stable of doctors that they use to evaluate you and to render opinions on your case. Again, we'll help you with that process, prepare you for that medical exam. After all of that's done, generally, like I said, takes about a year, then we move into what's called expert discovery. Both sides have the opportunity to hire experts to evaluate the legal claims. Those could be for liability, meaning who's at fault for the incident, or they could be medical experts to talk more about what injuries you did obtain and what the cause of those injuries is from, whether it's from the incident causing thing or pre-existing conditions, things like that. We'll hire experts, the other side will hire experts, and then both sides get the opportunity to find out the opinions of their other experts. That process typically takes about 6 months. Once that's all done, then we ask the court for a trial date, which kicks off the last phase, which is trial preparation and the trial. While some courts are still dealing with COVID backlog, it's impossible to know when and how long the trial date gets set for. But in general, it takes about 6 to 8 months for the court to set a trial date, which means we have 6 to 8 months to prepare for trial. Most of that work goes on behind the scenes, and you'll not be actively involved in that. Most of that is motion practice deciding evidentiary issues, preparing witnesses, things like that. About a month before trial, you'll meet with your attorney to discuss in detail what the trial will entail and your role in it. And we'll go over that in more detail as the time comes. The jury trial typically will last anywhere from 2 to 4 days in a typical injury case, and you'll be expected to be present for the jury trial. And you'll meet with your attorney regularly during that time to prepare and be ready for that event. Again, as we've gone through this process, there are lots of opportunities to settle your case. And in fact, most courts, before they give a jury trial date, will ask the parties to mediate the case. A mediation is a kind of a more formal opportunity to try to engage in settlement negotiations in which you hire a third-party neutral called a mediator to help you resolve your concerns and to hopefully resolve the case. While the process can be long, there are opportunities to settle the case throughout that opportunity. So that's the litigation process in general. Thanks for your time.